who not only holds a doctorate of literature and philosophy in criminology, but has vast experience as a prosecutor in magistrates' courts, 25 years experience in legal, child justice, crime prevention, and the criminal justice environment. She is currently serving as the Director of Child Justice and Family Law in the Department of Constitutional Development since 2013. I give you Dr. Charmaine Badenhorst. Thank you.
Thank you, Francesca. I am trying to put on my camera. I'm going to switch it off as soon as I start with the presentation, but it's just for people to see me, that I'm not in my pajamas. I don't know, it doesn't seem as if the camera wants to work. In the meantime, I will start with the sharing of the presentation.
Charmaine, please start your presentation. We can always show them your gorgeous face at a later opportunity. Thank you.
Thank you. I'm just trying to upload it quickly. My laptop's very slow. Just tell me if you can see it.
I can see the presentation now.
Thank you.
I would like to ask our attendees to note as our presenters go through the presentation that you please note your questions in the chat. Thank you. Thank you. Over to you, Charmaine.
Thank you. So basically, I'm going to focus on some of the changes that was brought about by the Domestic Violence Amendment Act 14 of 2021. The objects of this Amendment Act is to introduce and amend certain definitions in the Act to provide for further acts of domestic violence and related matters thereto, and also to further regulate protection orders in response to the acts of domestic violence. So I'm going to start off by focusing on some of the changes in the definitions. So the definition of a domestic violence relationship means the relationship between a complainant and the respondent. And the current legislation provided for 6 categories of a domestic violence relationship, and this is where people are married to each other, including a marriage to any law, in terms of any law, custom, or religion, whether they are in the same or opposite sex, live together in a relationship, and also if they are parents of a child or had parental responsibilities for that child, whether or not at the same time they are family members related by blood, affinity, or adoption. They are or were in engagement, dating, or a customary relationship, including an actual or perceived romantic relationship, intimate or sexual relationship. So this will also include where one of the parties is under the impression that there is a romantic or intimate or sexual relationship between the parties. The amendment that was brought in this specific definition relates to persons who are now in a close relationship that share the same residence are now also forming part of the definition of a domestic relationship. And for some reason, my computer don't want to move. Maybe I must press this one. Sorry, I don't know what's happening now.
Okay, we're asking everybody to bear with us because we have been having these little glitches throughout, and it is normally because of connectivity. So let's allow Charmaine a moment to sort out her presentation. Thank you so much. I encourage everybody to post questions in the chat. We will manage the time so that we have time to address the questions. Thank you.
Is it moving now, Francesca?
It's moving. It's moving.
Okay. I will have to leave this in this mode with the slides on the side, because otherwise it's not going to work. All right. So the next one is then the definition of domestic violence. So we are all familiar with the normal or the domestic acts of domestic violence that is currently in the Act. But now sexual harassment has been included. Also a related person abuse, spiritual abuse, elder abuse, which is very relevant to today's webinar, coercive behavior, controlling behavior, and also to expose a child to domestic violence. And these are all the underlined terms are all those that have now been included with the amendments. And controlling behavior occurs when a victim is made to be dependent on the abuser, where he isolates them from sources of support or try to regulate their everyday behavior or movement. So those are the changes, and I will highlight some of these in the following slides. So the definition also includes where there is entry into the permanent or temporary residence of the complainant without his or her consent, where the parties do not share the same residence, or, and this is also part of the amendments, the workplace or place of study without the consent of the complainant, where the parties do not share the same workplace or place of study. And also in any other, and then you will see that the words in brackets are those that have been taken out of the existing legislation. It says now that any other behavior of intimidating, threatening, abusive, degrading, offensive, or humiliating nature. So this has been expanded quite a lot, and where such conduct harms or inspires the reasonable belief that any harm may be caused to the complainant. So the words in brackets have been taken out just to improve the implementation and to extend the protection that are afforded to victims of domestic violence. So if we look at the definition of a close relationship, which was now also included, I refer to it as one of the now included domestic violence relationships that the Act now covers. A close relationship means a relationship between the complainant and any other person which the court with regard to the following criteria may consider as a close relationship of a person with the complainant. So the court will look at the degree of trust between the persons, the level of each person's dependence on and commitment to the other person, the length of the time that the relationship has existed, the frequency of contacts between the persons, or the degree of intimacy between the persons. So those are the criteria that the court will then take into account to ascertain whether or not these persons are in a domestic relationship. You referred to that specific part of inclusion in the Domestic Violence, when someone has committed to the Domestic Violence Act. So the Domestic Violence Act economic abuse have also been amended, and it now also includes that if a complainant is deprived of economic or financial resources, which he or she is entitled to under law, or that they require out of necessity. And now with the amendments, educational expenses has also been included with household necessities for the complainant, and mortgage and bond repayments, or the payment of rent of the shared residence or accommodation. And the respondent is now also not allowed to dispose of the household effects or other property that the complainant has an interest in without the complainant's permission. So those are the changes that have been brought about, but then the others are still applicable, where the respondent used the financial resources of the complainant without the complainant's permission, or coercing the complainant to relinquish control over assets or income, or sign legal documents that will enable the complainant's finances to be managed by another person. Elder abuse that has now been included in the amendments, the definition there states that it means the abuse of an older person as contemplated in Section 32 of the Older Persons Act, occurring within a domestic relationship, which I referred to earlier. Now, if we look at the Older Persons Act, that will refer to older persons abuse refers to any conduct or lack of appropriate action occurring within any relationship where there is an expectation of trust which causes harm or distress, or is likely to cause harm or distress to an older person, constitutes abuse of an older person. So if this is happening within a domestic relationship, then it constitutes domestic violence, and then the relevant remedies in terms of this piece of legislation can then be followed for older persons. So the definition of emotional, in the past, emotional, verbal, also and psychological abuse was always as one. So it was emotional, verbal, and psychological abuse, and that has now been amended to say or psychological abuse. So any of these abuses, either emotional or verbal or psychological, then falls under this definition, and it has also been expanded to include manipulating, threatening, offensive, and intimidating conduct towards the complainant that causes mental or psychological harm to the complainant. And then further amendments, you'll see that the repeated in the following paragraphs is in brackets. So that has been removed from with the amendments. So there's no need for complainants to prove repeated insults or repeated threats or repeated exhibition of obsessive possessiveness or jealousy. So because of the fact that it was difficult to ascertain when do you talk about repeated, when is it regarded as a repeated action. Now, if it happens, you don't have to prove that it's happening for a long time, or it happens on a lot of occasions. So those are the changes that has been brought about, which then also further will assist in complainants to come forward and to apply for protection orders and get relief or protection in terms of this domestic violence, of the Domestic Violence Act, because of the burden of the repeatedness that has been excluded from the amendments. Another Domestic Violence Act that has been inserted now is the exposure of a child to domestic violence. And this means to intentionally cause a child to see or hear domestic violence, or to experience the effect of domestic violence. So the protection of children have now also been highlighted and acknowledged, and children, and this aspect is now also part of the protection being provided. A functionary, and I will elaborate on that in a few slides. That means a medical practitioner, a healthcare personnel, a social worker, an official in employ of a public health establishment, an educator or caregiver, and then any other person designated by the minister to be regarded as a functionary, and the relevance of that will become clear. I also referred to in the acts of domestic violence, the inclusion of related person abuse. And now everyone is wondering, what is a related person? A related person means any member of the family or household of a complainant or a person in a close relationship with the complainant. So if a complainant is the victim of domestic violence, and the related person, which is then a family member or member of the household, is then being targeted by the respondent because of her or his or her relationship with the complainant, will now also be regarded as a domestic violence, act of domestic violence, and they will also now receive protection in terms of the Domestic Violence Act. Related person abuse, that was what I was just explaining, means to threaten the complainant with causing physical violence to or danger of the property of a related person. Threaten a related person with physical violence or causing damage to the property of such person. Threaten a related person with causing physical violence to or the damage of property of the complainant as an act of punishing the complainant. Commit an act of physical violence against or cause damage to property of a related person, and where these actions then cause harm in the circumstances to the complainant. That is what the definition of related person abuse. And as I indicated, this person can then also get assistance from the domestic violence for the protection against the respondent. So I referred to a functionary earlier, and I highlighted who are regarded as functionaries. So the reason why I've highlighted that is because in terms of the amendments of the Domestic Violence Act, there's now an obligation to report domestic violence. So first of all, the obligation is on a functionary, a person who's dealing with a victim of domestic violence, and I've indicated who a functionary is. So if a functionary, in the course of the performance of their duties or the exercise of their functions, obtain information which after evaluation by them causes them to believe or suspect on reasonable grounds that a child, a person with a disability, or an older person is a victim of domestic violence, they must then without delay, report the knowledge, belief, or suspicion to a social worker or a member of the South African Police. So this is applicable where a child, a person with a disability, or an older person is a victim of domestic violence. Then the obligation to report domestic violence is also extended to all adult persons who knows or believes or suspect on reasonable grounds that an act of domestic violence have been committed against, once again, a child, a person with disability, or an older person must also report that. So the Act then also provides protection to those that are reporting domestic violence by providing that any person, and this includes the functionary, who makes the report in good faith is not liable to civil, criminal, or disciplinary action on the basis of the report and is entitled to have their identity kept confidential unless the interests of justice require otherwise. So the Act places a responsibility on all of us to report acts of domestic violence against those 3 categories of persons. And if it's done in good faith, there is protection not to be charged or to be held accountable. If a person who has this knowledge do not report this knowledge or belief or suspicion, then they will be guilty of an offence in terms of the domestic violence. So, and I think this is a very huge improvement in the protection of the rights of children, persons with disabilities, and older persons, to make it the responsibility of everybody to be reporting. The Act also now amended the seizure of weapons. The court must now order a member of the South African police to seize any weapon. So the armed or dangerous have been taken out. It's any weapon in the possession or under the control of the respondent, which is specified in the order. And this is they can seize the weapon regardless of the requirements of the respondent's employment to possess such weapon. So if a person is employed in a position where they have a firearm or any other weapon and they need it for their work and they use that, or it's a risk to the complainant, the court can now order that it must be taken away or seized by the South African police, despite the fact that the respondent may need it for his work. And then the court must then be satisfied that the respondent has threatened or expressed the intention to kill or to injure themselves or any person in the domestic relationship or a related person. So here again, we can see the related person protection or any other person. And then the court will also take into account that or make this order if the possession of the weapon is not in the best interest of the respondent or any other person in a domestic relationship or related person, because the respondent's state of mind or mental condition, the inclination to violence, or the use of or dependence on intoxicating liquor or drugs. So these are the factors that the court will take into account when making the order for the seizure of the weapon. But the most important aspect here is that the excuse that the police cannot take away or seize the weapon because the respondent need it for their work is no longer applicable. The amendments also brought in the protection against a third-party actor, and this is something totally new. So the Act now provides that a complainant may apply for protection from a harassment order where a third-party actor, and the definition is below, I will get to that in a few moments, but where a third-party actor committed the act which, if it was committed by the respondent, would amount to a domestic violence against the complainant, and which constitutes harassment in terms of that act. So sometimes you will find that a respondent will use someone else to commit acts of domestic violence against a complainant because they don't want to get into trouble, so they're using someone else. So the complainant can now also seek relief against this third-party actor, and they can apply for a protection order against the respondent and at the same time apply for a protection order against the harassment against that third-party actor. And then if a respondent uses a third-party actor to commit an act of domestic violence against the complainant, for the purposes of the domestic violence, it is then regarded that as if the respondent committed the domestic violence personally. So a third-party actor is any person who is not or has not been in a domestic relationship with the victim, and any person who plotted with the abuser to commit an act of domestic violence against the victim, or any person who was bought or used by the abuser to commit an act of domestic violence against the victim and has committed the alleged act of domestic violence or aided the abuser to commit the alleged act of domestic violence. So again, this increases the protection of victims, because third parties are now also being held accountable for committing domestic violence act against a complainant. So if we then look at the application for a for a protection order, so any person who has been in a domestic relationship with someone who has been subjected to an act of domestic violence may apply for a domestic violence order, for a protection order. And any person, another person can also apply on behalf of the abused person or the victim if they are a functionary, and those are the ones that I referred to earlier: a social worker, healthcare professional, educator, etc. Or if they are a concerned person who has a material interest in the well-being of the complainant. So these people can apply on behalf of the victim, but the application on behalf of the complainant must be brought with the written consent of the complainant, except where the complainant is a child and the court is of the opinion or considers that the application is in the best interest of that child, or if the person is, in the opinion of the court, unable to provide the required consent. And it may be because the person is unconscious or whatever reason. In the opinion of the court can then allow for the application on behalf of the complainant. It is also important to note that any child or any person on behalf of a child can apply for a protection order without the consent or assistance of a parent, a guardian, or any other person. So a child can apply for a domestic violence order, and this is in acknowledgement of the fact that sometimes people that are committing the domestic violent acts against a child may be the parent or the guardian of that child. So the child now can also go to court and apply for a protection order. So where can people apply for a protection order? At any magistrate's court. So the courts that have jurisdictions is the court where the abused person permanently or temporarily reside, study, carry on business, or is employed, or where the abuser permanently, temporarily resides, study, carry on business, or is employed, or where the place where the act of the domestic violence occurred. So there's various magistrates' courts that will have jurisdiction in the application for a protection order. And the application can be lodged with the clerk of the court or electronically by submitting the application to an electronic address of the court that has jurisdiction of the application, and the department is also in the process of developing or implementing the online web portal where applications can be lodged. So in cases of an emergency application outside ordinary court hours or on a day which is not an ordinary court date, the application may be submitted directly to the court, and the court will give directions as to how this should be done. The amendments also introduced a domestic violence safety monitoring notice. So this is applicable in cases where the victim shares a joint residence with the abuser. So the complainant or the victim can apply for this domestic safety monitoring notice at the same time when they apply for the protection order, before the interim or the final order is issued by the court, or after they've obtained the interim or final order and it is in force. So at any time, the complainant can apply for this safety monitoring notice, and the complainant or the victim must then just provide supporting affidavits to show cause why it is necessary for the court to issue this safety monitoring notice, and to refer to the allegations, the proof of that there are weapons that are available to the abuser. Those are all factors that the court will take into account. And then the court then, after receiving all the information, may issue the domestic violence safety monitoring notice, which will then order the police to have electronic contact or physical visits with the victim to ensure that the victim is safe from the abuser. And this notice must be served on the police, the station commander of the South African Police Service and the abuser. And but there is a part, a annexure to this application, which must not be handed to the abuser. It is just for the police to. That's just something important to note, that information should not be handed over. So those are the most important amendments that I wanted to share today, and most important is the inclusion of older persons in the definition of domestic, or the abuse of older persons in the definition of domestic violence, that increase their protection in terms of this piece of legislation, and will also then ensure that they are protected from everybody with whom they share a domestic relationship. I just want to touch on the Criminal and Related Matters Amendment Act 12 of 2021 as well. And I'm just going to focus on the provisions that specifically relates to older persons. So the Magistrates Court Act and the Criminal Procedure Act have both been amended with this Criminal and Related Matters Amendment Act to now also provide that that intermediary services be extended to older persons, both in criminal proceedings as well as any other proceedings. So older persons can now apply to testify through an intermediary and not be exposed to the offender or the respondent in the court environment, and the court can issue this order for testifying through an intermediary if it appears to the court that the proceedings would expose such a person to undue psychological, mental, or emotional stress, trauma, or suffering, if the person have to testify at these proceedings. It also further states that no examination, cross-examination, or re-examination of any witness in respect of whom a court has appointed an intermediary may occur except through the intermediary. And the intermediary may convey the general purport of any question to the witness, so as to make it easier for the witness to understand what is being asked, especially if legal terminology is used. So if the court appoints an intermediary, the court can then also direct that the evidence through the intermediary be given at any place which is informally arranged to set the witness at ease, which is situated that any person whose presence may upset that witness is outside of the sight or hearing of the witness, and which enables the court and any other person whose presence is necessary at the relevant to see and hear the witness either directly or through the medium of electronic or other devices during the testimony. So if an application has been made for a witness, and now I'm specifically referring to older persons, if the court refuses the application for the appointment of an intermediary, the court must immediately provide reasons, and those reasons must be entered into the record of the proceedings. So if the court refused the application and it later on emerged that there are material change in respect of any fact or circumstances that influence that refusal, the court can then review its own decision and then allow for the person to testify through intermediary. Another change that has been made in terms of the Criminal Procedure Act, and that relates to bail. It also provides now that if an accused person who is in custody in respect of an offence that they've committed against the person in who they are in a domestic relationship with, or if they are charged for the contravention of a domestic violence protection order or a protection from harassment order, the police will no longer be allowed, as soon as the act comes into operation, to release that person on bail, and the prosecutor will also not be allowed to release that person on bail. It is only can release a person who's committed an offence against someone with whom they are in a domestic relationship with. Only the court can release those people on bail. And that is the end of my presentation. Thank you.
Thank you very much, Charmaine. Maybe you can try and switch your camera on. Anybody who wants to ask a question, please put your question in the chat. Mr. Peter Hugo, please put your question in the chat. We are first going to go to our next speaker, Miss Ntombi Matila. There's Charmaine. Hello. There she is. And thank you, Charmaine. That was very interesting. My comments with regards to the elderly experience of abuse is that, and in general with domestic violence, is that really the domestic safety monitoring notice is very, very important. I am very regretful that it took so long, but also, you know, the accountability of us, the general populace, that we are accountable when we suspect that violence is occurring in our environment or in a home, or, you know, that it is, the onus is now also on us to report. And if it can be proven later that you knew and you did not assist or report, that you will be held accountable by law. And the third party actor amendment is also of huge value going forward, not only with elderly, but with children, and of course in divorce disputes and things like that, because we all know very often, you know, divorces occur because of GBV in the home, and normally quite too late, and normally the perpetual secondary violence of a woman going through a divorce is really strenuous, not only on both parties, but also on the family, the children. And very often, people relying on the judicial system to assist them also reported judicial violence. The process of coping with the various aspects of the judiciary, the various processes and the demands thereof, was found very violent by some people. So please post your questions in the chat. We will hurry up and we will give at least 20 minutes at the end for questions to be answered. But right now, I want to introduce Ms. Ntombi Majila. She's the current registrar for the National Register of Sex Offenders, has 25 years experience in government, started her career at Home Affairs, then went on to SAPS, joined the DOJ in 2007, and was designated as registrar to the NRSO by the minister since its implementation in 2009. Now, welcome, Ntombi.
Thank you, Francesca.
The floor is yours, my dear.
Thank you very much. Would you allow me to share?
Please do.
I've been attempting to share my screen, and good afternoon, colleagues.
Charmaine, if you can help us for Ntombi to share a screen.
I'm not sure whether it is showing.
I don't see it and I don't have it. I've stopped sharing, so I'm sure you will be. Yeah, it's coming. No, it's not.
Okay.
No, it's not. No, I lied. It's not.
Yeah, because it's not opening the share tray, which is something that is odd on my part. Okay. Is it on?
Not yet.
Okay, let's all just be a little bit patient.
When I click or when I double click on share, it's not indicating that the share tray is open for me to share. Okay, I think now you can see it.
Yeah.
Okay, thank you very much. Thank you, Francesca, for...
Please, Ntombi, please go ahead.
Okay. Good afternoon, colleagues. My presentation today is going to focus on the Criminal Law, Sexual Offences and Related Matters Amendment Act, which is one of the acts amongst the 3 GBV acts that was forwarded for, or that was submitted for amendment, and which was subsequently approved by the President on the 28th of January 2022. So before we can subsequently get into what has been amended in terms of the law, I would like to give the context in terms of where we come from, so that you can have an appreciation of what has been amended subsequently. So the preamble of the Criminal Law, Sexual Offences Act 32 of 2007, which is the principal act. Basically, it is, or it was aimed at protecting the rights of vulnerable persons, but in this instance, we actually were looking at children and persons with mental disabilities, the society as a whole, and the economy. It further states that the Sexual Offences are primarily a social phenomenon which is reflective of deep-seated systemic dysfunctionality in our society, and that legal mechanisms to address the social phenomenon are limited and are reactive in nature, but nonetheless, they are all necessary. So the enactment or the initial enactment of the 2007 Act demonstrates the intentionality on the part of the legislature with being specific in the protection of children and persons with mental disabilities. That is why the National Register for Sex Offenders was created. So on the other hand, when we look into Section 2G of the Principal Act, it provides that the objects of the Act are to afford, which means the intention of the legislature at the time was to afford the complainants of sexual offenses the maximum and the least traumatizing protection that the law can provide. It also introduced the measures which seek to enable the relevant organs of state to give full effect to the provisions of the Act and to combat and ultimately eradicate the relatively high incidence of sexual offenses which were committed. So in this light, when you look into Section 42, it creates an obligation, or it created an obligation on the part of the minister at the time to establish and maintain the National Register for Sex Offenders, designate a fit and proper person as the registrar of the National Register for Sex Offenders, and it further provides that the registrar must exercise and perform his or her purpose, duties and functions subject to the provisions of Chapter 6 of the Act. So the purpose of the Principal Act, amongst other reasons, is stated as being to enact comprehensive provisions which were dealing with the creation of certain new, expanded and amended sexual offenses against children and persons with mental disabilities. As you would note, initially, the sexual offense that could take precedence at the time, it was rape. And then the limited definition as it was contained in the definition of rape was simply just looking into the unlawfulness of that act, a vagina and a penis. It did not look into all forms of sexual offenses that could be committed. And the reason at the time we had to look into children and persons who were with mental disabilities is because those two categories of persons do not have the appreciation, nor can they consent to a sexual offense or a sexual deed being committed with or against them. So it came out with, different functions in respect of which, it will deal with sexual abuse or exploitation, which the manner in which these would be addressed. So the functions upon which this act or the National Register was created was to prevent, or the main objective was to prevent repeat offending by inclusion of details of persons who were found guilty of sexual offenses against those two categories of persons, wherein in terms of Section 50, we had to also gather the historical and current convictions of persons who were previously convicted of committing sexual offenses against those two categories of persons. This we had to establish a register, collect data from the South African Police Service which related to the previous sexual offenses conviction. The Department of Correctional Services also was mandated to give some of the historical data. With the Department of Health, again, it was also obligated in terms of the law to provide those details that related to sexual offenses which was committed against children and persons with mental disabilities. But with the Department of Health, we could not obtain any information because of the reason that it was not a legislative obligation at the time for them to obligate to gather information that was coming from the courts convicting people who were convicted in terms of Section 77 and 78 of the Criminal Procedure Act. Another aspect, again, is to prevent persons who are previously convicted of committing sexual offenses against those two categories only to be placed in circumstances or instances where they will have access to them. This will do by issuing the certificates in respect of particulars. Section 41 again is the one that is set out to prohibit employment or for a person who is holding. I'm receiving feedback and I don't know who is it from, Francesca, and I'm distracted. Can the person please mute so that I can focus? And Section 41 prohibits the employment or for anyone who is actually holding any position which places him in a position of authority, supervision, or care of a child or persons with mental. It further prohibits that we can grant or any institution that grants licenses to manage or operate any entity, business, concern, or trade in relation to the supervision over and care of a child or a person with mental disability. So the establishment of the National Register for Sex Offenders was done so or was provided for in terms of Chapter 6 of the Principal Act, with the aim to regulate only the management and administration of the National Register for Sex Offenders. So in short, it requires that the particulars of persons who have been previously or currently convicted of committing a sexual offense against those two be included or recorded in the National Register for Sex Offenders. It also places a prohibition on them not to work or be placed in circumstances where they will have access to those two categories. So relevant employers, again, were or are still required to vet existing employees or potential employees against the National Register for Sex Offenders in order to determine whether they are suitable to work with children and persons with mental disabilities. So how then the whole 2007 is composed? I'm only going to focus or just give you a brief synopsis. On Chapter 1, you will have the definitions, the objects, and everything else. And then on Chapter 2, this is where it outlines the types of sexual offenses that there are. Chapter 3 and Chapter 4. Chapter 3 specifically focused on sexual offenses that can be committed against the child. And Chapter 4 focused on sexual offenses that can be committed against a person with mental disabilities. And then Chapter 5, it dealt with the HIV, we call it the HIV chapter, wherein if you require that a person who has committed a sexual offense against you be subjected to an HIV test to ascertain whether or not they were not infected as such. And then Chapter 6 focuses on the National Register for Sex Offenders. So how it is composed. On Chapter 40, you will have the different definitions where it defines who the employer is, who is the child, what type of a sexual offense can be committed against who, and so on and so forth. And then Section 41, it looks into the prohibition, who is actually prohibited from accessing or working with children and persons who are with mental disabilities. And Section 42, I've alluded to that. It deals or it looks at the establishment of the National Register and the designation of the registrar. And then Section 43 are the objects. Section 44 is who is actually entitled to apply for a certificate in respect of particulars. Section 45 are the obligations which are placed in respect of employers rather. And then section 46, obligations of employees, wherein it forces an employee who has a previous conviction to disclose such to the employer. And then if that person is placed where these two categories of persons are, it is either the employer has got the obligation of removing him and placing him where they cannot access them. Or if you do not have such a place, then you need to let them go by dismissing them. Because in terms of this particular act, anyone who has a previous sexual offences conviction cannot work with children or persons who are mentally disabled. So in section 47, it outlines the obligations in respect of license applications, those institutions that issue out licenses to those people that need to open up creches, or those institutions that look after or work with children and persons who are mentally disabled, or persons with mental disabilities. My apology. And section 48 is the one that outlines the obligations in respect of applications where a person needs to apply for foster care, kinship caregiving, and temporary safe caregiving, adoption of children, and curatorship. This is where it says if you want to adopt a child or any other processes that are outlined therein, you need to apply for a clearance certificate that actually ascertains that you do not have a previous sexual offences conviction, to which the court need to take heed of before they can actually allow you to adopt or foster a child or any other processes that you see therein. Section 49, it outlines the contents of the register. When we talk about the contents, we talk about what information can be kept in the register, or what information as the Department of Justice do we gather as it relates to a convicted sex offender. And section 50, it says the persons whose names must be included. Who is this person that can be included in the National Register for Sex Offenders? It is that one that has been convicted of committing a sexual offense. And then section 51, it talks to the removal of particulars from the register, the circumstances or instances on how you can apply for removal only if you do qualify. And section 52 is the one that talks to the confidentiality and disclosure of information. As you are well aware, the National Register for Sex Offenders is held in a confidential manner. And this particular issue, when we were dealing with the amendment of the Act, it came prominently in the discussions and the deliberations, and also when we were looking into the comments that we received from the public, because people were looking into instances wherein they wanted to protect themselves. And by protecting themselves is that they sought to know whether or not the person that I'm dating, the person that I'm living next door to, whether or not they are not convicted sex offenders. So this one had to look deeper into whether or not we can make the register public. But the reason why we did not, or that could not be approved by Parliament, is because disclosing someone's particulars outside of those people that are required to apply for and receive the certificate, they said like it would not pass the constitutional muster, which means if we were to be challenged on the basis that we have disclosed information in the register, we would not, succeed on the basis that us giving out the information contained in the register, we are violating another right, which is the right to privacy, as well as another piece of legislation that is currently at play, which is the promotion of personal information, the protection of personal information. Because when you want to receive another person's personal information, at least that particular person needs to consent thereto. So that one was not allowed on the basis of the disclosure of information, to what extent we can disclose that information. Section 53 deals with the regulation, and then Section 54, Dr. Badenhorst has also touched on that as part of what has been amended in terms of the domestic violence. You would see the similarities in those pieces of legislation, although here we still had an obligation placed for someone who is aware that a sexual offense against children or persons with mental disabilities is being committed, to report such. However, we did not have a punitive measure to say, in the event that I don't report, what's going to happen to me. So we have amended Section 54 as well to articulate what will then be the consequences of you not reporting. You will see in domestic violence again, people are obligated to report because it discourages any bystanderism, to say when we can win, this scourge of GBV, the one thing that we can collectively do is to report the wrongdoing on the part of perpetrators. So now we will get on to the Criminal Law, Sexual Offences and Related Matters Amendment Act 13 of 2021. This is the new amendment. The Amendment Act also still outlaws sexual exploitation and sexual grooming of children and persons with mental disabilities. It provides that perpetrators of any sexual offenses against vulnerable persons must be recorded in the National Register for Sex Offenders. So now you will see the narrative changing. We no longer deal with the two categories of persons, which are children and persons with mental disabilities, but the focus now is on who is a vulnerable person. We have extended a scope, because when the president, as Francesca said when she was opening, or when she was giving the opening remarks, this is what she said, that when people marched, the president got on, and then one of the primary objectives of strengthening the criminal justice system was to look into the changing of the National Register for Sex Offenders, to give focus to what is it that was not working within the National Register for Sex Offenders. So one of the primary aspects that was brought into play was to extend the scope of the National Register for Sex Offenders, for it not to look only onto the two categories of persons, but to extend it to look into now all categories of vulnerable persons. We will soon zoom into who are the vulnerable persons when we get onto the slides below. So in this manner, this is how Parliament responded to calls to tighten up the management of the sex offenders. So those who have been convicted of committing any sexual offenses against vulnerable persons, or if you have a conviction which exceeds 18 months, you will not be removed. But when you have a conviction that is up to 18 months, at least we can talk about who and under what circumstances can you be removed. This is where the timeframes for someone who is actually put in the register for sex offenders were doubled. Now we will focus into the objectives of the Amendment Act, what this amendment sought to do. So the amendments to the 2007, the primary objective was to extend the ambit of the offense of incest, so as to provide additional protection to children. Another aspect, it introduced a new offense of sexual intimidation to protect persons from threats of imminent sexual harm. It substituted now the phrase persons who is mentally disabled or persons who are mentally disabled wherever the phrase appears with the phrase persons or a person with mental disabilities. You will also note, colleagues, that I'm struggling a lot, to say persons with mental disabilities, but it's a work in progress issue where I'm going to improve, because the phrase person who is mentally disabled, it's something that was used in the Principal Act. So wherever it appears, it has been changed to reflect persons with mental disabilities. It further regulates the inclusion of particulars in the National Register for Sex Offenders. In the previous dispensation, the only people who could be included for commission of a sexual offense or for conviction of a sexual offense, it was those who have committed such against children and persons with mental disabilities. Now, the narrative has changed. Anybody who is found guilty of committing a sexual offense against anyone, irrespective of who they are, your name will be included in the National Register for Sex Offenders come commencement date. It has also extended the list of persons who are to be protected in terms of Chapter 6. This is the category of vulnerable persons. So in addition to the inclusion, or in addition to a child or a person with mental disability, we have now welcomed another family of vulnerable persons. And these are a female under the age of 25 years, but that person we qualified and saying it is only that one under the age of 25 years who receives tuition at a higher education college, higher education institution, or university college as defined in Section 1 of the Higher Education Act of 1997. Or this under 25 year receives vocational training at any training institute other than the institutions referred to above as part of their employment. We probably, maybe this relates, not maybe, can also include, or it relates to those that are now serving internship in those institutions, or those ones that are doing practicals, teaching, stuff like that, or who lives in a building or a structure or facility which is used primarily for any of the persons referred to above. The under 25 female student, and those who are living where in a building, structure, or facility used primarily for any of the persons referred, okay? And persons who is being cared for or sheltered in a facility that provides services to victims of crime. Again, we have another category. It's a person with physical, intellectual, or sensory disability. In the previous dispensation, or in the 2007 Principal Act, it only focused to persons with mental disabilities, the only disability that it could cater for. It was a mental disability. But now you can see the scope has been expanded to say that person can have a physical disability, intellectual disability, or sensory disability, but who receives community-based care and support services other than from a family member, or who lives in a building, structure, or facility used primarily as a residence for, or is cared for in a facility providing a 24-hour care to persons with physical, intellectual, or sensory disability. Now we get to a category of older persons. You see, it skips from 25 to 59. It skips that, and then it goes to a person who is 60 years of age or older. This is the older persons where we're saying the focus now, it's on older person. But the older person, anyone who is already 60 is included, and who receives a community-based care and support services other than from a family member, who lives in a building or structure or facility which is used as a resident and is cared for in a facility that provides a 24-hour care to such persons. So the objectives are continued, that the purpose of an amendment, again, is to extend the list of persons who are entitled to submit the application to the registrar of the NRSO. Initially, we had 6 categories of persons who were entitled to submit the applications for a certificate, because it was held in a confidential manner, but it was available in a prescribed manner, which means by way of application you could apply, but not everyone could apply for a certificate in respect of particulars to check whether anyone is recorded in the National Register for Sex Offenders or not. So those categories of persons, we were looking at that you will have a person who is applying on their own behalf, like for own particulars, and then you will have an employer who is actually applying on behalf of employees. You will have a licensing authority that wants to deal with applications for licenses for those people that wants to open those institutions that work with children or persons with mental disabilities. We have the relevant authority wherein a court that determines an application for adoption, foster care, and all those related ones was actually included. You'll have an employee who will submit in his or her own right. And then you will have a that person that was applying for I've already mentioned it, that one that was applying for foster care, or you would have a government department or a court that was applying on behalf of another. And then you will have any person who knows that there are particulars or who suspect that I've got a previous conviction. Now I want to see if my details were listed in the National Register for Sex Offenders or not. Another objective, it further regulates the removal of particulars of person from the NRSO. It will also regulate the reporting duty of a person who is aware that a sexual offense has been committed against the person who is vulnerable. So wherever we had a child or someone who has a mental disability, all those words have been substituted with a vulnerable person because they are included in the list of vulnerable persons. So these people who are entitled to apply, these are the ones which I've just reflected to now. Now, as an addition to these 7 categories of person, you have now any person who wants to determine whether the particulars of any person have been included in the National Register for Sex Offenders or not. But that is not a blanket provision that you can say when you feel like you want to check whether or not your neighbor is in the National Register for Sex Offenders, you can simply submit, because then there is this provision that actually allows any person who wants to determine whether the particulars of any person have been included. The Amendment Act in that aspect, although it outlines that it allows that any person who wants to determine can apply, there are conditions that the registrar or the person who performs those functions on behalf of the registrar must be satisfied that the application that has been submitted thereof, it is not frivolous or vexatious, or whether the person who has submitted the application has an interest in the disclosure of such information, and the disclosure of the information is in the interest of an identifiable vulnerable person. So this actually, when we were looking into what was actually amended over and above what I've just presented in terms of content of saying this is what has been amended, this is what has been substituted. Most of the amendments in the National Register for Sex Offenders were technical, in that in terms of accommodating this particular provision, we had to come up with additional forms in the regulations, which will outline, because this type of an application is the one that is submitted in terms of an affidavit. And the registrar or anyone who is discharging those functions on behalf of the registrar, upon determining whether or not there's frivolity or vexatiousness, they can respond in a form of a response, but not a certificate per se, to say we cannot proceed with your application because it is vexatious, frivolous, or it's not in the interest of a vulnerable person. So these amendments, in as far as it relates to the older persons, it is the extension of the scope, as well as the extension of the timeframes upon which a person can qualify to have their details removed. Initially, we had instances if a person is convicted of a sexual offense and they've been given to just about 18 months, they will have to stay in the register for 10 years before they can apply to have their details removed. Now they're going to stay for 20 years. The one that was supposed to stay for 7 years, we have doubled that to 14 years. The one with the lesser conviction, we're looking into the one which is below 6 months or lesser in nature. That one was supposed to stay for 5 years, but now they will have to stay for 10 years before they can actually apply to have their details removed from the register. So the protection now of the register, or the ambit of the scope, has been extended to older persons as well, wherein they can be beneficiaries of the protection by the National Register for Sex Offenders, as what has been available to children and persons with mental disabilities. So Francesca, this will bring me to the end of the presentation, and I really thank you for the opportunity to share this with the colleagues out there. Thank you very much.
Thank you very much, Ntombe. We're going to go straight into the questions that were posted in the chat now. First, I'm going to address Charmaine, Dr. Badenhorst. Can you please answer the question posted by Peter Hugo? He says, in relation to locus standi, who can bring the application for such a protective provision for an intermediary in civil proceedings in terms of the Domestic Violence Act and Older Person Act, and when comes to matters where elderly people is an applicant complainant? I understand the locus standi in criminal proceedings. So let us address who can bring the application. I don't know if you had a moment to look at the other questions. Thandi, there are some questions posted to you in the chat. Charmaine, can you please answer those questions that are addressed to you, please?
So in civil proceedings. So they can do the application themselves. In criminal proceedings, the prosecutor will bring the application. In civil or other proceedings, violence proceedings, the older person can ask the court if they can make use of intermediate.
Thank you very much. And we have another question. Let me just find it because there's been so many movements in this chat. Okay. Then Civil Legodu asks, can older persons not be allowed to appeal against the court decision relating to refusal to grant intermediary service upon receipt of outcome of application, rather than wait for the possibility of material facts on the matter being picked up by the court? So basically, it was also supported later in the group. When we heard that the court can review its own decision, is there going to be a way for older persons to appeal themselves?
Look, the way that provision was construed was to indicate that the court might have taken a decision. Usually when a court makes a decision, let me start there. When the court makes a decision, they cannot change that decision because in legal terms you say they are functus officio. They've already made a decision. So if you want to have that decision changed, you need to take the case on review. And because the court cannot change their own decision. But in this, with regard to the appointment of an intermediary or allowing a witness to testify, the Act says if it becomes then clear later on to the court that there's new facts or issues that were not considered when they made that decision, they can then go back on that decision and change it. So that is basically then to prevent the case being taken on review outside of the proceedings that is currently before court, because it delays the finalization. So if there's no such new circumstances or new facts that comes to the attention, and the person who applied for testifying through an intermediary does not agree with the court's decision, they can take that decision on review, the refusal on review. But this just gives the court the opportunity to have a second bite at the cake, if I can call it that, to say that. But if someone then comes in and says, but this has not been placed before court, this is why we need the person to testify through it, the court can change the decision in the same case.
Thank you so much. I hope that is clear. Another question, and this is actually very important, comes from Leando. Ask, is there a plan for guidelines relating to being aware of abuse, as it may be very subjective, and more especially that failure to report constitute a criminal offence? Do we have guidelines, Charmaine? Is there a way that we're going to not only educate the public, but also our first responders in terms of GBV, elderly violence, domestic violence? Are there guidelines? Are we training enough? Are we making it known enough? Please answer that one.
Okay, so the way that the reporting of domestic violence, and I assume that the person who asked the question refers to where ordinary people should be reporting domestic violence committed against a child, an older person, or a person with a mental disability. And I think we must be clear that those are the instances where the obligation is on you to report. Ne? So in those circumstances, you report your belief or your suspicion or the knowledge that you have to the police or to a social worker. And they will then investigate the the allegations or the belief or the suspicion. And based on that, they will then, take the issue further and take the necessary steps. So for someone, if you have a bona fide belief that someone is subjected, those 3 categories are subjected to domestic violence, report it, and then those functionaries will then investigate and then take the matter further. So it's going to, because sometimes we suspect, and there's things that, and you report that, and then they will investigate with the powers that they have and the resources to find out, is it true, is it happening, and then they will take it further from there.
Thank you so much.
I think there is a need to then, ensure that people understand that, and that, we're not all experts, and we don't have, we all have, and I mean, we all know domestic violence is a very private crime or issue that's happening. So your suspicions should be reported, and the investigation will follow.
Absolutely. Thank you for that, Charmaine. I also just want to intercede here. Domestic violence has always been regarded as some sort of stigma. And very often families would know about it, and even, happen upon such events, but would not take action because it was regarded as a stigma. And we are trying to break that confine of attitude that it is a stigma, because it is something that impacts our societies at the core. And therefore, the inclusion of functionaries and the accountability would then really make it possible for a teacher who might notice bruises, who might notice a change in persona, and or the actions of a child that is in its care or in its class. And I think that is very, very important. So I hope that question was answered well. And I also saw Charmaine actually answered another question in the chat. Elder abuse is now regarded as domestic violence. So provisions of the Domestic Violence Act and the protection provided must be brought to the attention of older persons, and they need to be informed of their rights. That is why we invited you here, our friends, our guests, our colleagues, because this is part of what we as a society must do. This is not only the onus that is depending on a government. We need to be informing each other of our rights. We need to actually talk to each other. That is very important. Lona said, I have a very similar question as the one above. Are persons with sexual offences convictions allowed to work with older persons? And Tombi, that one will be addressed by you. I have a serious interest in this because, we didn't have this information at hand previously, and we don't know how long, we never knew how long a person could be on this register and how they can get off. And there was a case very much recently that I was involved in, where, to my dismay, I discovered that a professional that I was employed, was actually a pedophile, a sex offender against children. So, I mean, thank God, it wasn't close to my children, but as a moral human being, I don't want to be employing such a person. So can you please answer that one for us, Ntombi?
Oh, yes, definitely, Francesca. I'm not sure if I got the question, the circumstances under a person, circumstances under which a person can be removed from the register. Is that the question?
No, they want to know if a person that is on the register should be working with the elderly.
No. remember, the reason I gave the contextual background on how the act was and who it protected, I wanted to bring the audience to the appreciation of what has changed. Initially, it protected the children and persons with mental disabilities, and anyone who is found guilty of committing sexual offenses against them was not allowed to work with them. So now that the scope has been extended to include all vulnerable persons, which are inclusive of older persons, anyone who has a sexual offenses conviction against their name is not allowed to work with older persons or access them in any circumstances. So the protection that has been afforded to children and mentally disabled persons has now been extended to include older persons or wherever they can be congregate, whether it be at a nursing home or at your house. If you've got an older parent and then you are hiring a helper to come and look after them or a nurse, you need to apply for a certificate to check whether or not that person that you want to hire in that space are not listed in the National Register for Sex Offenders. So this will apply for all vulnerable persons that we have outlined in terms of the new amendment.
Thank you so much. And I would like you, I know you did address it in your presentation, but I see, when I scan through the questions, what is important is for people to know, and if you can just reiterate the periods that a person may be on it, and what can happen that they can be removed from the register.
Okay. A person can be included in the National Register for Sex Offenders, bottom line, upon conviction. Whether or not the sentence is a suspended sentence, it's a, what do they call it? Whether it's a suspended sentence or whether or not the person did not serve jail time, whether I've seen mostly the courts issuing fines for a sexual offense, which I do not understand, but it doesn't matter what kind of a sentence that has been afforded to a convicted person. At first, for a lesser sentence, what we had actually looked at was someone who has been sentenced to less than 6 months. That person was supposed to stay in the register for 5 years before they can actually apply to have their name removed from the register. 5 years has been doubled, it's 10 years now. So for a person who has been sentenced to a period of between 6 months and 12 months in between, that person was supposed to stay in the register for 7 years, but now that has been doubled to 14 years. And the one that has just been given for 18 months was supposed to apply to have their details removed from the register after 10 years has lapsed, but now the 10 years has been doubled to 20 years. But a person who's got more than 18 months or has got 2 or more convictions, that person's name may not be removed from the register.
Thank you so much. We have a question here from Gugu. Are there any plans from Justice Society to share this information with the affected sectors? I think, these webinars are our initiation phase, but Charmaine, if you want to come in, if there's anybody else here, then Charmaine, that would like to answer that. Yes, I know there are, but let us give Dr. Badenhorst, the opportunity to answer that question, please. Charmaine?
Yes, sorry. Yes, definitely. The department is in the process now of having hosting these webinars, and there's quite a few of them still coming. You know, to inform, but also in the public, the community outreaches. There will be media coverage as soon as the acts come into operation. Definitely, and information booklets will be issued, and all sectors will be informed of the provisions of the Act and the changes and improvements. So definitely that is something that the department is working on. We have a public education team that is looking at that with newspaper adverts, interviews on television with the principals of the department. So definitely the information will be made available, and also, you know, in different languages and in different formats. So yes, we are aware of the fact that I mean, these amendments will mean nothing if people who have if those who are that they are intended for is not aware of them. So definitely the department will be embarking on such a drive.
Thank you, Charmaine. And there's another question here by Vernon that I want to address to you. Vernon asked, is there perhaps a notion where we can have posters in cryptic and user-friendly forms to be posted in centers for the use of older persons?
Yes, that will all form part of the educational drive, you know, for the department. And remember, there are various stakeholders involved in this process. So it's not only the Department of Justice, South African Police, the Department of Social Development. So this information needs to be spread by all of us to everybody, and it needs to be visible at all the service points of the different stakeholders, so that everyone, you know, is aware of their rights and their right to protection in terms of all three these different parts, the different pieces of legislation. So thank you for that comment, and that is something that we are definitely working on. And we also, you know, have a very close relationship with the Department of Social Development, whose mandate where the mandate of older persons fall, and there will be a collaboration with them as well to ensure that the information is spread to all their partners in the older persons sector, and all the others, the victim sector, etc.
Good. Thank you so much. I just want to tell everybody that's attending, you know, there's a vast group of departments that are involved here. We are talking about not only all the branches of justice, but social development, South African Police Services, Department of Health, and to an extent, even, you know, Department of Stats, Stats South Africa will be involved. So the involvement and moving forward and making the information aware is really vast. And I think, you know, we just need to also be conscious that we ourselves can educate the society that we know and those around us. I want to conclude with you, Ntombi. Google asked about the description in the NRSO and the amendments to the Sexual Offences Act. I saw that you gave an answer here. Can you just please explain the context and your answer?
Yes, if I can simplify it, on the definition of vulnerable persons, it says a person who is 60 years of age or older. And then it qualifies, not only that, it only covers those ones that are in community-based care or who are receiving support services. It wanted to cover even those ones that are in the homes and everybody else. But once you are 60 and you are at home, you are an older person, irrespective of where you are. And then in covering who is receiving community-based, we wanted to cover the whole scope of older person, which is inclusive of not only the ones that are in those community-based care or support, or who are receiving support services. So it's all the older persons, because if you can see in terms of my presentation, the definition of vulnerable person, it says it's a person who is 60 years of age or older, and who. So which means the 60 years of age older person, as long as you are defined as an older person, you become a beneficiary of protection in terms of this amendment.
Thank you very much, Ntombi. With that, I'm going to conclude this webinar, and I want to extend my gratitude to each and every one of you who had attended today, and also to our presenters, Dr. Shamaine Badenhorst and Ms. Ntombi Majila. I am absolutely honored to have narrated this for you, and I am grateful to everybody who posted their questions, and we will send the presentations to everybody who posted their emails in the chat. So if you have not done so yet, and you would like to receive the presentations from Department of Justice, then please put your emails in the chat, and we will do so. And with that, I am going to close this meeting, and I'm going to thank everybody who has participated, and have a wonderful weekend. And please go out and share this new insights that you have obtained today. Thank you very much.
Thank you. And I just want to thank you, Francesca, for moderating this this webinar for us, and for the information that you provided, the introduction and setting of the scene. And it's much appreciated. And thank you so much. And enjoy your weekend too.
Thank you.
Thank you so much, Francesca, from our part as well. And we thank you, the colleagues, for this participatory session. We can only learn from one another and improve, the landscape of our country, and ensuring that all of us take a part to fight the gender-based violence and femicide. We can only emerge better after this. Thank you so much, colleagues, for your time, and thanks everybody.
Thank you so much.
Bye.
Shamaine, if you and I can just have a word quickly, I will appreciate that.
Okay, I'll stay on.
Thank you.
Bye.
Okay. People still think they can come in. Shame. I'm going to ask everybody to leave. I just would like to have a word with Dr. Badenhorst. Thank you.